Welcome to the Hastings Shadmary Show.
I'm Andee Hastings.
And I'm Mali Shadmary.
Together, we own Hastings Shadmary, an Atlanta-based law firm specializing in family law.
This is a space where we talk all things family law and all topics that touch the area of family law, from divorce to custody to self-growth, personal empowerment, and more. We bring you the truth, from our wolf pack to yours. Hello, and welcome to the Hastings Shadmary Show. I'm Mali, and today we're going to be talking about temporary hearings, a very hot topic. But before we do, we got to start. I got to ask my co-host, my best friend, my business partner, Andee Hastings. First of all, how are you?
Oh, I'm great.
Are you?
I'm just happy to be here.
Okay.
I missed you last week.
Oh, I missed you too. Oh my God. That's a long story. So, Andee, in true Hastings Shadmary fashion, are you a warrior or are you a diplomat today?
100% a warrior today.
Okay.
So we're mediating a case today, and the mediator came on, and in their prefatory remarks to our client explained that we are a firm that has a reputation for being aggressive litigators. Like that's a bad thing.
Like that's a bad thing.
But
thank you for the compliment, actually.
Right. That's literally what I was saying. And of course, I don't know if it was intended to be a positive or a negative, but the client loved it. And so that is that. So yes, today, very much a warrior.
Okay.
How about you? Warrior or diplomat?
Well, I would say warrior because I was out of town in Miami. Talked about it a little bit last time. Do not go to Miami if you want to have a relaxing vacation. Okay, that's all I'm going to say on here. Andee, I'll tell you all the details tomorrow.
I still haven't heard them.
I know, we haven't had time since I've been back, and that's why I'm in warrior mode, because you get back from vacation, my bags still are not unpacked. They're upstairs in my closet, just whatever. All my toiletries still packed. I came back, I was like, gotta go to work. Did not even unpack because the whole Delta thing happened. So we came back later than anticipated. I was exhausted. I've been a zombie the past couple of days, but mama came back to get to work. So warrior mode. I have a couple trials coming up in the next few weeks.
Sleep deprived. It's okay.
Oh my God. Yesterday, I was getting Starbucks on my way here, and I was innocently waiting in the line.
I know whatever's about to be. It was not innocent.
I really was. And I didn't happen to see that someone was going to be backing out of his parking spot. He did not initiate backing out until I was already in my spot in the drive-thru line. I hear yelling as I order my drink, and the Starbucks lady's like, ma'am, what did you say? I'm like, I don't know. Somebody's yelling in the background. I'm like, I don't know. And then I placed my order again because she couldn't hear me. And I get my order, and I'm like moving up, and all of a sudden this guy backs out, and he zooms up like right next to me and flicks me off and spits at my car. And I truly was like, well, that hurt my feelings. And I did just do this to him because I don't know you. Why are you so mad at Starbucks? What are you doing? So that put me in warrior mode too. Don't spit on my car.
That's just...
Ew. Literally ew. And then today, they made me pour my Starbucks into our Hastings Shadmary swag because Starbucks is not sponsoring us. So they would not let me.
Thank you, Cotter
Bay. In the background. Yes. Yeah.
Cotter would kill us. What would Cotter do?
So I'm drinking my cold brew out of my little thing.
Oh, and also, just for the record, Mali's version of being a zombie is like most people going at about 90 miles an hour. Okay.
Actually, Andee too.
Oh, no, not like this.
Okay.
Not like this one.
We're both pretty hard to keep up with. But we don't think that. We think this is perfect pace. You're a Lovey.
You're a Lovey.
What? Tell them what a Lovey is. Tell them.
So, okay. My husband and I have a name. We call each other Lovey. Everybody has their thing. And so it's not unusual for us if he is somewhere else in the house and I'm not with him, I'll text him and I'll say, Lovey, blah, blah, blah. So apparently one day I thought I was texting Ned, and I texted Mali, and I said, Lovey, blah, blah, blah. And then I didn't get a response. And so I was like, Lovey? And
then enters Mali Shadmary, because I was not, Andee and I started as an associate attorney for Andee, and I just looked up to her and still do, and hung it on to every word that she said. And, when you're starting with someone new, especially a mentor that you really look up to, is this like around 6 years ago, maybe? We weren't texting each other Lovey yet. I wasn't telling you all my crazy stories yet. That started later when Andee would be like, sit down. What are you doing? And so I get this text, and I think it was like early in the morning. I remember I was working out or something, and she texted me, can you bring me something, Lovey? And I was like, oh God, she meant to send that to Ned. Didn't say anything. So when she sent the follow-up one and was like, Lovey? I died. And I was like, hey, Lovey. So from that point on, I became a Lovey as well. Exactly. And now we have a group text with me, Andee, and Ned called Loveys. And that's that.
That's that.
So we're not just warriors, diplomats. We're Loveys too.
Oh my gosh. Thank God we cleared that one up for all you inquiring minds.
Now ready to talk about the law.
So I was thinking that we talk a little bit about temporary hearings today. I feel like a lot of people that are starting the process are scared. They have a lot of questions, especially if it's tense about, well, how do I have to leave the house? How do I get my spouse to leave the house? How will bills get paid? Those sorts of things. Mm-hmm. And people have been asking that a lot lately. So I know that it's on people's minds, especially with inflation and the costs of things these days. So how do you feel about helping folks have a better understanding of temporary hearings and how we address some of those issues?
Yes, I think that there's kind of two avenues, two mindsets that a party can take when considering a temporary hearing. The first avenue is going to be the most cost efficient, the cheapest option, and the one that if you can do it, we're going to encourage you to do that. That is maintain the status quo. Hold on to your life where it's at right now, even if you live under the same roof as your spouse. Do that. You're going to spend a lot more money on a temporary hearing and then potential motions hearings, other types of hearings, a final hearing. Avenue one is maintain status quo, let your lawyers do their thing, see if y'all can get resolved in the first few months with your divorce, and that's going to be best case scenario. Option two, avenue two, is a temporary hearing, meaning I cannot wait until the final conclusion of this case to get out of this from underneath of the same roof with this person, or maybe y'all have already moved out, but suddenly this person has cut you off financially and you have zero money, and it has become a situation where you just can't live anymore without court intervention and a court order because they're not agreeing. A temporary hearing is going to be necessary when a situation arises that you really cannot live with and the lawyers cannot work out outside of court. And I do see people jump too quickly to a temporary hearing, especially sometimes inexperienced lawyers, because when I was younger, I didn't know either. I would always have to lean on my mentors and say, when is it time to pull the trigger? This is very nerve-wracking. I want to know, when should we actually go do it? So it is kind of hard to determine when is the water boiling over. What do you have to say on that piece?
Well, a couple things. One of the things that I like to do at the beginning of a case when we get in is take the temperature of the other side, usually through their attorney, and just start the conversation. I like to feel them out, see, is there a resolution that we can come to? Is it their perspective that there are tensions that we need to help alleviate? Mm-hmm. And then, see if we can't work out everything. Are there certain things we can work out? Because it's difficult under the best of circumstances for people to continue to live under the same roof when they don't have guardrails. And so we start there, we take the temperature, and then we decide relatively quickly whether or not it's going to need to move to a temporary hearing and how much of a battle that's going to be. If all the issues are in play or if only certain ones. One of the things that people ask all the time is, can I move out? What if they don't let me see my kids? And so what do you tell people when they ask you that, Mally?
It's so fact specific, but if they're going to want some equity in the house at the end of the case, which everybody does, and there might be an issue that arises with are they still contributing financially to the house, it's going to protect your interest in the equity in the house usually to continue, even if you have to move out, at least contribute towards some of the monthly expenses to the house if you have been traditionally. But on the topic of children, you moving out of the house, it is so fact specific. There are some cases where it would honestly be stronger for you to stick it out and stay in the house and do not move out if you want to maintain primary physical custody. There are other situations where it doesn't impact the circumstances so much for you to move out. The big thing is if you have children, you don't want to pick up and move the kids out unless you're moving them to where you know your next permanent place is going to be. We want as little changes as possible for the children throughout this process. So that's one of the big things I'm thinking about, and what it all really comes down to is having a lawyer that knows your judge, which the judge likely to do, likely to think, the jurisdiction. That's half the battle as well, which we can talk about. But yeah, what about you? How do you think moving out during the pendency of the case impacts a temp hearing or temp issues?
Well, I completely agree that it is very fact specific. But when there are children involved, it gets a little bit tricky. If it's highly contentious and there are children involved, you want to get people out from underneath the same roof as quickly as possible, because what we don't want to do is expose the kids to the litigation or all of the difficulties going on between the parties. However, it may take a moment, getting to your point about what's the process to get a temporary hearing. And if we cannot agree, then sometimes we will tell our clients, you need to stay there until we come up with a parenting plan, at least come up with a parenting plan. Even if we can't resolve all other temporary issues, we need to have something put in place, the guardrails, so to speak, that everybody has to operate under while the case is pending. So if it's a highly contentious case, sometimes people unfortunately use the children as weapons in the case against the other party. And if we have the client that the other party is trying to weaponize the kids with, then we'll try to get a parenting plan in place quickly, or that might guide our time frame to get to the court. But generally, I like for clients in those specific situations to stay until we have that nailed down. Unless there are issues of family violence or something like that. None of this is that situation. It's more a matter of just kind of trying to peacefully coexist to the best of your ability until we can nail that down.
Yes. One thing we need to cover is, what are the things you can get out of a temporary hearing? Like, what are you going to get? It can be a myriad of things. And it is kind of funny, trivial. But what a lot of people, when emotions are high, because remember what we've taught you on here, family law attorneys bridge the gap between emotion and business. And when emotions are high, a lot of people come in and they want that hearing and put them on the stand. And Mally, I hired you because you're this aggressive litigator. Let's go. I want to see it. And I'm like, no, that happens at the right time, in the right place, if it's really warranted. We're not going to go to argue over which furniture you should get immediately in your case because you want to move out right now, and we're fighting over the salt and pepper shakers. I will never forget one of my favorite judges saying, because opposing counsel brought this up at a temporary hearing, I'll never forget it, some little tiny teddy bear salt and pepper shakers. And they're like, and we want the bear family salt and pepper shakers. And the judge was like, I can't believe you're in here at a temporary hearing bringing up bear family salt and pepper shakers. So that kind of stuff's going to happen later in your case. The most common categories you'd walk away with some kind of result with a temporary hearing would be some type of child support, some type of temporary alimony, if your case is an alimony case, a living arrangement potentially, meaning who gets to stay in the marital residence as their primary residence right now. Sometimes temporary attorney's fees. Sometimes we leave with an arrangement on, all right, breadwinner, you have access to all the finances, and you've spent this on your lawyer. He or she needs this, so you're going to be responsible for paying X amount per month to this lawyer, or usually not monthly, but a lump sum is what you'll see. What other temporary issue? You can get more specific on temporary issues depending on what the temporary specific problems are. Obviously, a temporary parenting plan you can walk away with. And if we're noticing some serious co-parenting issues or problems with the children, we can get some real specific language about not videoing the children, stop using the children as pawns in you trying to concoct your divorce story for everyone. That's pretty common when the water is boiling over and you need a temp hearing.
Don't monitor the children's communication with the other parent, those kinds of things as well.
And oftentimes, you've heard us talk about what a guardian ad litem is. A neutral third party that comes in and does an investigation on what custodial arrangement would best serve the children's interests in this case. And the judge can, but doesn't have to, follow the recommendation of the guardian. And a lot of times when you have a temporary hearing, you're going to walk away with a guardian ad litem. And a smart lawyer is going to have asked for one prior to the temporary hearing, so by the time you get there, the judge knows that issue is ripe, that the court can hear that issue because someone's asked for a guardian. So tactically, if you're going to go to a temporary hearing, you want to knock out as many issues as efficiently as possible as you can, with the goal being, let me get my client to a livable circumstance. You're not going to walk away with all the money and be living freely. I always am encouraging my clients to go seek employment even before a temp hearing, so the judge knows you're trying.
Yes, if you've been out of the workforce, those sorts of things we want you looking at. One other thing that I know that we deal with at temporary hearings or in temporary orders, temporary agreements, is how are certain bills paid? I mean, we deal with child support, and temporary alimony potentially. But then we've got all these bills that if you've got a certain credit card debts that require monthly payments or minimum payments, we need to make sure that somebody is responsible for that, because if nobody is, then it's possible nobody will, and that'll become a weapon in the case too if they think they can hurt your credit, even if it's hurting their own. So, we deal with all of those things as well, just trying to keep the house in order while we get you through to the end. That's the purpose of a temporary hearing. It is like a mini trial.
It definitely is, and so it's going to front load the costs in your case. You're going to spend a lot for your lawyer to get the groundwork done, get exhibits. I mean, it's a full trial day. Temporary hearings are typically shorter than final hearings, and it just varies. It's anywhere from an hour to 8 hours. I've definitely had full day temp hearings, and I've had 2-day temp hearings. And another common, so you could just go to a temporary hearing on one issue only, like child support only, for example. And like one example that I have, it's a hearing we did a long time ago, and the people already had a parenting plan in place. This was a modification, and we went to a temporary hearing that lasted a day and a half, and the dad had developed really bad drinking issues since the last parenting plan had been entered. So we had to go have a temporary hearing to say, this case is pending. We don't know what we're going to do on a final basis yet. We need a guardian ad litem. This is really serious because what we're looking at potentially is supervised visits forever for these children if dad keeps acting the way that he is right now. And judges typically don't like to do supervised visits for all of eternity for children. That's really not supportive to children and conducive to them developing a realistic bond with their parents. So typically you're going to see supervised visits happen in tiers, and they should go away over time. But like if, in this particular case, it was like we had to go put up so much evidence to prove why on at least a temporary basis, this guy has to have supervised visits. And then what happened in that case was he did get ordered for supervised visits, despite the other side arguing till like they were blue in the face that he didn't need that. And which just kills me because he did need that, because he started going to these supervised visits, and the supervisors will take reports of everything that happens at these visits. And it came out that during these supervised visits, which were happening after our temporary hearing while the case was still pending, he was showing up drunk to the visits. And had we not fought for that, these kids would have been potentially being driven around drunk, with a drunk dad. He was showing up to their sporting events drunk, all kinds of things. So that temporary hearing in that case was very expensive. By the time we got to a final, it was more expensive because we had to go through all the supervision reports. We got one of the best parenting plans ever at the end of that case. But that one is an example of, like if you need something done temporarily, expect it to feel more like a final hearing. My temporary hearings, it just varies on the case, but they're typically going to range anywhere from $20,000 to $40,000. I had one recently, it's $50,000. The issues were insane. When you have complex issues, it's going to cost you more. So I think that's something, I want to hear what you have to say about that, like the cost of them. I think clients think, oh, temporary, easy. Like we just have to say how mean he is or she is in the house. No, And it's going to usually be much more expensive than you think.
It usually is, and
If you want it done right.
well, right. You don't want us just rolling in there with a pad of paper and our smiles, hoping to get all of the things for you on a temporary basis. There's a lot of strategy that goes into every piece of a case that includes a temporary hearing. And one of the reasons you have to show up like it's a mini trial is because somebody could come out of that hearing feeling emboldened in their behavior. So if we don't come absolutely prepared, which is just kind of our reputation, we are going to prepare for we're going to think through every possibility that we can, and be ready for that. Be ready for what the other side is going to say. Be ready for what the other side might present as argument and evidence. Have evidence to respond to that. We're not there to try all the reasons for the divorce, if there's adultery or things like that, but things that do pertain to what the judge is dealing with on a temporary If there are abuse issues, that's very relevant on a temporary basis. So we have to go in ready. We prepare opening statements. We prepare a direct examination for our client, cross-examination of the other side. We have to get witness affidavits, depending on the situation with regards to custody. We have to line up all of our evidence, make sure our financial information is on point, because there's a couple things that people don't think about with temporary hearings. One is this is our first opportunity to talk to the court about your case. And we're building credibility or cashing it in when we do that. We go to build credibility. We want the judge to know that we're on the right side of whatever it is that we're doing, and we want the judge to have a good impression of you, a good impression of us, which reflects on you, on the case, the facts, and everything, because that's going to affect how the judge looks at your case for the rest of the case. That requires strategy, planning, and that's why it's a mini trial.
For sure. And temporary hearings have different rules, different etiquette, if you will, at least in Georgia under the Superior Court rules. There's different rules that apply on what you can present and how you present it versus a final hearing. So I see a lot of mistakes in that regard. Judges do expect you to streamline your case much more in temporary hearings. And even more so at a temporary, I feel like it's more important to know your judge, because you are really expected to get in and get out. And a common roadblock, especially if your lawyer doesn't know the jurisdiction that they're in, is how to actually even obtain a temporary hearing. Different judges have different rules on when they're going to allow you to have a temporary hearing and how they want you to even request it through their office. One jurisdiction, Forsyth County, my hometown, my place I love to practice, is very specific. They are not going to give you a temp hearing unless you mediate first. And a lot of times that really is, leaves my clients feeling downtrodden. What, I got to go spend money on a mediation when all I want to do is go to a temporary hearing? And the answer is yes, because judges expect that smart and responsible lawyers are going to make a good faith effort to settle the temporary issues before coming to a temporary hearing. And even if your jurisdiction doesn't require mediation before a temporary, I'm not going to court without telling the judge truthfully, Your Honor, I have tried to work these issues out, and we simply cannot. And that goes to what Andee was saying, which is we go to establish credibility, not cash it in. I'm not going to be the lawyer that walks into that courtroom and the judge is going to say, it's Mali. I know she caused everybody to come in here because she wasn't being reasonable. Like, that's just not going to happen.
No.
So expect your lawyer to try to settle the temp issues. And if they don't do that, if they are not trying to make a valiant effort and they're keeping you informed of that, hey, what do you think about this temporary offer? Let me give it to them. Let's see what they say. Your lawyer should be working through that with you. Honestly, ideally, before you even request the temporary hearing. If they're not, and they're just saying, temporary hearing, blasé about it, red flag. The preparation for a temporary hearing really starts the second you retain your lawyer.
Agree.
It's not just get up and go. And there are situations where you're going to get an emergency temporary hearing. Emergency hearing is a temporary hearing. It's just on an emergency basis, meaning something catastrophic really has happened, and the judge will get you in more quickly then. And having a credible lawyer that's going to put that in writing and say, Judge, emergency, that we really mean it. Judges know who's crying wolf and who's not. Unfortunately, sometimes that's the truth. So you might not be required to mediate if it's an emergency situation, and your lawyer will be the one to know, which option it is.
Again, with the strategy, when we tell the court something's an emergency, it's not just because we think it's one, it's because we believe the court will see it as an emergency. And those two things are not always the same, but that's part of building your credibility as a party to this litigation. We're not going to roll up in there and say it's an emergency as to who gets control over the Lamborghini. And yes, that was an issue in a case. So judge isn't going to see that as an emergency.
No.
But if children are in danger, or, if we're if we're in danger of losing the house, but even then, when it comes to money, they don't generally see that. It has to be danger to life and limb.
Yeah.
So we have to be very careful about that.
For emergencies. Yeah, one of the common fact patterns I had for a while was really sad. It just happened to be moms. I was representing dads. This is like several years ago. I continuously had situation arise where, like, they would have a toddler, and and divorce is pending or about to be pending, whatever, and the toddler is running out of the mom's closet with a heroin needle. I've had multiple cases like that, and judge will get you in so fast on things like that. Addiction issues and that are impacting children. It's really sad, things like that.
I agree.
So yeah. That's temp hearings.
Hopefully we answered your questions. We have talked about this a little bit here and there, but not as specifically in the past. But definitely come to our podcast on YouTube, Hastings Chad Mary Show. We're on TikTok and Instagram as well, and we're here to help guide you through the process to the best of our ability.
Yes, we're also on Apple and Spotify, and that's all we got for today, and we will see you next time.
See you next time.
The Hastings Shad Mary Show is a production of Hastings Shad Mary Family Law and 1066 Productions. Produced by Ned Hastings and Kendall Walker, and edited by Ned Hastings.